Good evening. I am Jeb Mays, the Spanish interpreter. I'm going to explain how to access the interpretation. Buenas tardes, mi nombre es Jeb Mays, soy la intérprete español y les voy a explicar cómo accesar la interpretación. We should make that happen now so that people can see it.
I think we are not able to hear Jeb because she's now in the Spanish channel, so I can make the announcement. Okay. Buenas tardes. Esta noche, bienvenidos al foro de candidatos para District Attorney en el condado de Essex. Esta noche tenemos interpretación disponible al español. Si usted desea escuchar este programa en español, por favor mire la parte inferior de su pantalla. Bien abajo hay un globito que parece un mundo y dice Interpretation. Por favor, elija Interpretation. Y después de hacer clic en ese globito puede elegir Spanish y ahí podrá escuchar el audio en español.
Hello and welcome to the Essex County District Attorneys Forum. I'm Stephanie Traina of the Andover North Andover League of Women Voters. This nonpartisan forum is a collaboration of League of Women Voters chapters in Essex County, the League of Women Voters of Massachusetts, the Massachusetts Women of Color Coalition, the ACLU of Massachusetts, the Dream Network, Courageous Conversations, Essex County Community Organization, NAACP Merrimack Valley, and NAACP North Shore. The questions this evening are both a result of this collaborative effort and the League of Women Voters and partner-led outreach for questions from the public. This event is being recorded and all attendees will get an email with the link. It will also be posted on the League of Women Voters of Massachusetts YouTube channel. Sue Flykop is our moderator tonight. Sue is a longtime League member and currently a Wayland resident, but she was born and raised in Essex County. With thanks from the ACLU, we have Jeb Mays with us to provide Spanish translation. I'll turn things over to Sue Flykop, our moderator. Sue, you are muted.
I am sorry. Thank you. Thank you, Stephanie, and welcome everyone to this candidates forum. We have two candidates for Essex County District Attorney. We have Paul Tucker and James O'Shea. I'll start by explaining some procedures for the forum, which each candidate received ahead of time. Each candidate will have 2 minutes for an opening statement, 2 minutes for a closing statement, and 90 seconds to answer each question. If the rebuttals will be at my discretion, and the closing statements will be done in reverse order from the opening statements. When there is when there's half a minute left on the candidate's speaking time, the timekeeper will alert them that they have 30 seconds to finish their answer. At 15 seconds, the timekeeper will alert them as well, and they will wrap up when they see stop from the timekeeper. If they continue speaking after the stop sign, I will say thank you, and we'll move on to the next speaker. We've asked the candidates that personal references about the other candidate are out of order. And we want to let you know that this forum is being broadcast live and will be rebroadcast several times online. There will be no questions fielded from the audience this evening, as we have collected questions from our various community partners ahead of time, in interest of time and to adequately represent the issues that matter to the community. I just wanted to add one more thing. If you need to see the text of what we are saying, you can click on view full transcript in the live transcript icon at the bottom of the screen. Okay, so we are ready to start our opening statements, and we are going to go with Mr. Tucker first. 2 minutes to you, please.
Great, thank you, Sue, and thank you to all the presenters. This is an extraordinary group, and I've had the good fortune to work with many of you in my police career and in my legislative career, so a deep thank you to all of you. The reason why I'm running is this is a pivotal moment in our country and in our state. We've had a racial reckoning. We are finally doing some things to take a look at what's most important, what can we do to move our criminal justice system forward and to be fair. And as I quickly go through my background, I ask that you consider the breadth and depth of my experience and what I've done up to this point that's led me to run for district attorney. I had a 32-year career at the Salem Police Department. Most of my career I spent as a detective. And as such, there wasn't any type of crime that I didn't see or have the opportunity to work with the district attorney's office closely as part of the prosecution team in over 1,000 cases from arrest to verdict. For 17 of those years, I was the captain in charge of the detective unit. And during that time, I was also a member of the DA's domestic violence team. During that time, I attended night school. I went to law school, 3 years. I graduated in 2000. I took the bar and passed it. And for over 2 decades, I've been an attorney. I've worked with victims. I've worked with the DA's office. I've seen the full spectrum of what the criminal justice has to bear. In 2009, I was appointed the police chief by Mayor Driscoll. And we took some very innovative steps when I was the chief. I believe we were the first police department under my tenure to hire mental health clinicians, to bring social workers, to put them in the cruises with police officers. We learned early on that we can't arrest our way out of problems. We can't incarcerate our way out of problems. So we really tried to disrupt the pipeline that was bringing folks, particularly folks on the streets, people with mental health issues, people with substance use issues, and in fact, in many cases, dual diagnosis. Instead of bringing them to the station, bringing them to court, and then having them arrested, we disrupted that pipeline.
Thank you. Mr. O'Shea, 2 minutes to you.
Thank you so much, Sue, and thank you to everyone on the panel that made this possible and for having us and hosting this event. I've been a practicing attorney for 24 years. This office means a great deal to me, and I can't tell you how important it is. Unfortunately, on the campaign trail, sometimes you hear and you encounter folks that say, what's the DA's office? What do they do? There isn't as much interest or notice about what the district attorney's office does in the general public because it's a down ballot race and it doesn't always get the attention that it deserves. And I appreciate the fact that you're hosting a forum like this so we can educate people as to our backgrounds and what we bring to the table to run this very important office. For 24 years, I've been a bar advocate in Lynn, where I grew up. I represent indigent defendants of all races, backgrounds, sexual orientation. 17 of those years, I've been partnered with attorney Helene Morris, a super lawyer in immigration. During that time, we've had the great privilege to represent people from all over the world. And we've encountered people who have been the victims of human rights abuses and all kinds of criminal victimization throughout the world. We've had the ability to work with them and adjust their status, bring them to the United States. And let me tell you, there's nothing more rewarding than allowing somebody to adjust their status, to change their life entirely through that process. My slogan in this race is experience over politics. And what I mean by experience is recent and relevant experience. You have to be in the fray. You have to be a trial lawyer in order to run this office. And that's not just me saying that. That's the history of the office itself. If you look at the people that have held the job, this is a situation where we have to have somebody that's familiar with the court process, somebody that knows it, not just from arraignment to verdict, but all the steps in between, including plea dispositions. Thank you for hosting, and I look forward to answering your questions.
Okay, thank you. For our viewers, we're just going to take a minute and repeat the instructions on how to receive the translations. So it's over to you, Laura.
Buenas tardes y bienvenidos a este foro. Esta noche tenemos interpretación al español. Si usted quiere escuchar este programa en español, simplemente mire la parte inferior de su pantalla. Ahí abajo va a encontrar un globito que parece un mundo y dice Interpretation. Haga clic sobre ese globo y elija Spanish para escuchar el audio en español.
Thank you. And for those people who would like to see text of our speech, you can click on live transcript on the bottom of your screen and then view full transcript and you will see text. All right, we are ready to start our question section. And James, this first question is to you first. What do you consider the top responsibilities of the district attorney? You've already touched on that, so maybe you can expand on it a little more.
Certainly, Sue. The top goal of the district attorney's office is to balance public safety with the interests of justice. In Essex County, we're currently out of balance. What you see and what I've seen from working with the people at the DREAM Network is that we have a grossly disproportionate number of people of color that are being incarcerated at an alarming rate, as well as in the Latina community. That needs to stop. And one of the ways, one of my approaches to this will be to slow down and stop the number of 58A dangerous motions that are being filed, which are being filed at a much higher rate than in other counties. In Lawrence alone, we're filing more of these motions in Essex County than we are in some whole other counties. I believe that there's a direct correlation between this injustice, and I believe that I can correct it. You only know about these things if you're actually in the court practicing law, seeing them. I can give you an actual example of somebody that suffered through this. A few weeks ago, I had the opportunity to represent a client who's a Haitian American. He was pulled over and stopped by the police after an alleged road rage incident. He was taken and the police called him and said, come to the station. He went, gave a statement. He was stopped days later again and questioned by the state police yet again. They let him go. They brought him back, and ultimately he was taken to court and they filed a dangerousness hearing in that case, even though he complied with the police twice. That's wrong.
Okay, thank you. Paul, what do you consider the top responsibilities of the district attorney?
Thank you. I think first and foremost, it's to secure justice, not to simply secure convictions. It has to be done in a full and fair way that does balance public safety. I also think that you have to be a visionary. You have to look ahead, find out what the best practices are, and make sure you're on the cutting edge. I did that as a police chief, and I did that as an 8-year state legislator. I also think that we need to make sure that we treat our assistant DAs fairly in terms of compensation. And in utmost fairness, something that I've actually worked on is to increase the compensation rate for bar advocates. We don't have a system that works fully and robustly unless we have good representation on both sides. I also think that we need to get into the programming very deeply. I helped 28 years ago to start a program with DA Kevin Burke. And last week, I was privileged to go back and speak at the graduation. And some of the parents that were there were campers when we first started. It's about programming. It's about prevention. And the biggest pieces that I will get on day one is helping folks with substance use disorder and mental health issues. There is a world of difference between somebody who's in the recovery community, somebody who needs our help and our treatment, versus somebody who is trafficking in substances like fentanyl. We missed this for a long time. For too long, we had a punishment-based system. We need to make sure we make good, smart, discretionary decisions.
Okay, thank you. Paul, this next question is to you first. As district attorney, how would you engage with communities to show that your office is committed to promoting public safety and trust with equal justice under the law as your guiding principle?
That's one of the most important things I've done in my public service career, was community-based. When I was the police chief in Salem, I approached Mayor Driscoll. We had an abandoned building down the Point section of Salem, which is a primarily Latino neighborhood, strong, vibrant, great neighborhood. I approached Mayor Driscoll and I was able to get funding to put that building to good use, a community-based use. We ran after-school programs. We ran teen girls sexual health. We ran ESL classes after school. That's just one piece of what we should do. The current DA's office, I think, has done a very good job of community-based programs. An example of that is John Blodgett's Breed All-Star program at Breed Junior High in Lynn. The more community programming we do, the more proactive that we are, we can stop these folks, particularly these young people, from coming into the system. We know that exponentially, the data is there. If we can keep somebody out of the system into their early 20s, chances are they will not enter that criminal justice system. We also need to make sure that we give second chances when appropriate. So many young kids that have gotten into trouble in a punishment-based system have a record that followed them into adulthood. That's wrong. We need to make sure that we make those good discretionary decisions, and when appropriate, put some youth into diversion. Make sure that we're giving kids a second chance so they don't have a record that follows them into adulthood.
Thank you. James, the same question to you. Would you like me to repeat it?
No, I think I have it, Sue. I think one of the ways that we can do this best is through transparency. I would be working with groups just like the Dream Network and doing outreach with them to follow the statistics to make sure that we're providing justice to everybody, to make sure that we make actual solutions to the social justice problem that I discussed in my opening and a little bit after that. I would agree that John Blodgett's project, as far as the Breed School, is working very well. That's something that I would continue on. But we have to continue to expand upon what we've seen. You have to see what's working and what's not working in the court system. With respect to the drug court, we have right now a more of a stick approach than a carrot approach. It's presented to my clients as a punishment rather than an encouragement of hope. To address the opiate epidemic and to solve some of these systemic problems within the community, you need to give encouragement like diversion. And one of the things I would do is to flip the switch on this and go with a program that says to people, if you can show sustained sobriety, we're going to allow you to avoid a conviction that will saddle you with potential unemployment problems. This is where the community issues lie. As far as outreach is concerned, I would reach out to the Dream Network. We would be transparent. We would do a lot more in terms of data collection in trying to solve this problem above and beyond the 58 A's.
Okay, thank you. James, this next question is to you first. As the Essex County District Attorney, what plans do you have to address the rise in hate crimes? And how will you monitor and prosecute?
I would prosecute hate crimes to the fullest. The identification of them is usually pretty, unfortunately, very in your face and not very well hidden. This is not something that I would take lightly. This is a situation where these are the crimes that need to be punished. In my administration, we will divide our approach and punishment on two separate things, and they both comply with the existing law. The first is we're going to punish the bad actors based on evil intent. Hate crimes are among the more evil intended crimes. Those people will receive the full brunt of the office in terms of the punishment side and imprisonment side of the office's powers. They'll be indicted and they'll be prosecuted. With respect to the second portion of our justice system, which is reserved for rehabilitation, that will be reserved for people that suffer from diseases like the disease of addiction or the disease of mental illness. So my plan follows with the law, specifically with regard to hate crimes, but also with regard to any crime. What we're punishing is the evil intention, the evil acts. And that's the way our system of justice was set up. That's the way crimes are punished if you look at how they're set up in terms of their statutory content, whether they're felonies or misdemeanors. So that's how I would approach that issue. I would punish hate crimes. They're easy to identify for the most part because of their in your face.
Okay, thank you. Paul, the same
Thank you.
question to you.
The statistics are very clear. Hate crimes are on the rise. We live in a society where we've seen so many of these terrible, terrible crimes that have come about because of anti-Semitism, because of anti-LGBTQ+. They're on the rise and it needs to be called out and stopped. As a police chief and as a police captain, I investigated and/or went to every community group that unfortunately had to suffer because of hate crimes. I've been a longtime board member of the Anti-Defamation League. I'm on the North Shore Advisory Board where I still serve today. We confront these issues every month. I've been to so many community vigils, and I will say, sometimes the silver lining in this is the community will come together. I've stood at vigils in Salem, in Swampscott, in Marblehead, across Essex County. People will come together. This is not a bystander approach. This is something where the community needs to stand with the police, with the district attorney's office, and show that this will not stand. The rise of hate crime is frightening. We've seen it in Boston just within the last couple of weeks. If we don't collectively, as a society, speak of our outrage for this, then acquiescence will let this take over. We can't let that happen. It's not just graffiti. It's not just words. Words matter. Things like this matter. And collectively, we have to show that we'll stand up to it.
Okay, thank you very much. The next question has a little prologue to it, so that all our viewers are aware of some of the language that's used. And this will actually go to Paul first.
Okay.
Essex County has nearly 50% of the state's upheld dangerousness hearings. And this is something that actually I think James alluded to. They're used to hold individuals for 90 days because they have been deemed a threat to an individual or public safety. In particular, Lynn and Lawrence, two of our most diverse communities, are driving these numbers. What are your views on the impact of the proposed bill to expand pretrial detention and sentencing? And how would you ensure there is no racial disparity, all while keeping people safe?
I'm glad you brought this up. I think this is one of the actual issues of the day that I think needs the most attention. So the 58A, as we know, it's to hold somebody is dangerous. Let's be clear right up front. These people that we're talking about here, that the DA could seek to hold, people that are charged with some extremely serious crimes, either multiple offense OUIs, multiple offenses of drug offenses, trafficking, violent crimes. Now, having said that, the ability of the DA to ask for these 58A hearings is immense, and it must be done with very good reasoning and very good discretion. People should also know that simply the DA asking for a dangerousness hearing does not mean the person will be held all the way through. They're asking for a hearing. I will also add that although Essex County has, by the numbers that seem to be high, in half of those cases where a judge holds a person as being dangerous, there's also the opportunity for release with conditions. In terms of the expansion, I favor much of the expansion as Governor Baker has. That doesn't mean we're going to hold more people. It simply gives judges an opportunity to make these considerations as long as it's compatible with public safety. If you ask the folks that are in the system, we're making sure at the DA's perspective that these are the people that they are not incompatible with public safety, and sometimes they have to be held. It should be done with good discretion.
Thank you. And James, the same question to you.
Thanks so much, Sue. We're missing the mark on the 58As by a wide margin. This isn't making us safer. It's just locking up people in disproportionate numbers, particularly with respect to people of color. I truly believe that there's a direct correlation to that. What we're really missing about the public safety side of this, and I'm there and I've argued hundreds, if not definitely hundreds of these motions over my 24 years. What we're missing is that the most effective means when you are, as a district attorney, identify somebody as dangerous is to indict them. That's why we differentiate between the district and superior court offenses. Right now, the reason that Essex has so many is that they're using the wrong approach in the office. They're filing these motions based on the nature of the charge, where the facts can be completely different. Instead of filing the motions based on the facts, circumstances, and evidence of each case, every defendant deserves that. Let me talk about the bill now with respect to Governor Baker, and something that I don't think is widely understood. That was going to increase the amount of time that someone could be held from 120 days to 1 year. If you have someone who's serving the maximum sentence on a district court sentence of 2.5 years in the House of Correction, their parole eligibility on 30 months is 15 months. That creates a potential hypothetical for the person that's held for a year to be held for a year and then found not guilty with the presumption of innocence, which is only 3 months less than a maximum offender. That's unjust.
Sue, may I have the 1 minute rebuttal?
Actually, the 30-second rebuttals.
I'm sorry,
yes.
30 seconds. Thank you.
Yes.
So just so we're clear, the decisions on whether somebody is held does not lie with the DA's office. This is within the appropriate discretion of the judge. And it is a full and fair hearing with all of the due process that a defendant should have. What we're talking about here is among some of the more difficult cases and serious felonies. Domestic violence cases where strangulation was in play, multiple OUIs. I don't think anybody wants to argue the fact that the public safety has to be at the top of the priority.
James, would you like 30 seconds?
I absolutely would. Having argued many of these motions, I can tell you they're being filed in cases where they're picking clients out of court that come to court for the first time on a summons arraignment. It's completely wrong. It's completely twisted. They are not doing this in a just fashion. It doesn't serve public safety. It only serves to protect the office. They put the onus on the judge. This is more importantly, the biggest part of this. There is a time period where there's a delay for the hearing of a three days where someone could lose their employment and often does lose their employment because they're working blue collar jobs. There's a real problem here in terms of the domino effect of these motions.
Oh, okay. We have a lot of questions here. I can tell this is a point of contention, but we do want to cover very many topics. So we will be moving on. If you want to continue this discussion, you can actually add it to your closing statement if you want. All right, James, the next question is going to go to you first. What do you do to recruit, or what would you do to recruit prosecutors of color and increase diversity of employees at all levels?
Well, I have a very diverse office as it is now. My assistant is from El Salvador. My partner is from Egypt, and my mentor, who just passed away, was originally from Poland. What I would do is I want to recruit the best people in a colorblind fashion, which is how I've run my practice and how we've run everything that we do on a regular basis. It's not going to matter. We want the most qualified people. And the way to do that is to simply send out and have people come in and accept all resumes, accept all comers, and review them based on their qualifications. I think there will be plenty of people of color that will apply to the DA's office, and they will be treated in the fashion with everybody else, and they will be hired with their qualifications. And that's how we're going to approach hiring people. This is a situation where I already have so many outreaches within the people that I know and the connections that I have in terms of who I have employed in the past, where hiring people of color is not a problem for me. It never has been, and it never will be. This is a situation where we have internships within the communities, and we would expand upon those. Those are the programs that we would continue with, but this is not going to be a problem for me based on my history.
Okay, thank you. Paul, the same question to you.
Sure. One of the best predictors of what you'll do in the future is what you've done in the past. When I was the police chief in Salem, we had a very robust outreach to help diversify our police department. My predecessor began that, and I carried it on. In Salem, we have a very diverse community, and the goal always was and should be to have a department that looks like your community. We've done that. When I first joined the police department in 1983, it was 99% white males. It was 2 officers of color and 2 females. It took work. We got it done. Now our police department is extremely diverse, not only in terms of gender or in terms of native countries and multi-generations. We have a department that looks like the community. And it, by the way, is also bilingual as well. When I teach at North Shore Community, which I've done for 20 years, it's important to point out that in the law enforcement major, there are more students of color taking classes to become police officers than there are white students. That, to me, is something that we need to keep working on to develop a career track. We need to make sure that we do outreach, whether it's at law schools, making sure that we have a culturally competent place to work, that people want to work there, that we reach out and make sure that we have a career track to support these folks. It makes for a better office, and I think it makes better for the pursuit of justice.
Okay, thank you. Next question is to Paul first. What is your plan to ensure transparency in data collection including about charging, sentencing, and other aspects of your office performance. What will be your policy on public records requests?
So as I was, as a police chief, extremely transparent. I know that under the FOIA request, there are some exemptions to it. And there are some, I think, that have to be held confidential, whether it's names of sexual assault victims or domestic violence. Other than that, we should be as transparent as we can, not only with the public, but with the media. I've done that as a police executive. I would do it as the district attorney. People have a right to know what's happening. The other piece of it is, and I think this is a good time to mention it, 2 weeks ago at the State House, as a member of the House of Representatives, I voted for an IT bond bill. It's about $170 million. It's going to transform us. One of the points that was made as we were voting, this is going to move us at least 25 years ahead. I've read that Harvard study on the racial disparities, and time again, it was the difficulties in trying to find the data, the silos between the police, parole, probation, the courts, trying to marshal that data and actually do something in a workable fashion looked like it was almost impossible to the Harvard researchers. I'm hoping that with this IT bond bill, we're going to move this forward so far ahead, you'll have it at your fingertips. The public has a right to know it. Whenever it seems that anything is being withheld, that erodes confidence in the entire justice system. And I think it's incumbent upon all leaders to put everything out there, no matter what it looks like.
Thank you. James, a minute and a half to you.
One of the things that, Sue, that I recently had the opportunity to do was speak to some of the media members and during the course of the campaign. And one of their great criticisms of the current office is that they're not transparent enough. In reviewing the data that we've discussed somewhat as to the completely disproportionate incarceration of people of color, Latino and Latino community members, this is something that had come up during the campaign. And the best I could think of to answer that question was to say, let's attack the 58 A's. I think we're going to be successful in making that reduction by reducing those motions, but that's not a panacea. We're going to have to go much further than that. And in discussing this with the people from the DREAM Network, I think one of the things we have to do is spend some money and allocate some resources from the office, from the district attorney's office, to engage in further study as to why these things are happening, to engage and work with people from organizations like the DREAM Network and say, what is it that you need for data in order to be able to determine how we reduce these numbers? This is among the most pressing problems that we have within Essex County. This is something that I've taken head on, something I've taken extremely serious, and I've developed a beginning of a very concrete plan that I think will result in immediate results and reductions in those numbers. But we don't get to stop there. We have to go forward and look at the data and work collaboratively and come up with additional solutions to get rid of this social justice problem.
Okay, thank you. James, this next question is to you first. What reforms in the criminal legal system do you support to improve recidivism outcomes for juvenile and young adults aged 18 to 25 years old?
I think we have to see additional diversion type of issues. I think we have to focus both on two things. First is one of the things that John Blodgett has started, which is addressing this before the crimes are happening, preventative measures, working within the schools, adding these programs and expounding upon them. It's not enough to just start at certain junior high schools. We need to take that a bit further. And we need to develop other diversionary programs for those that actually do end up, once they're in the criminal justice system. We need to address the problems that come with why these children are committing crimes. Most of the basis for why a kid ends up in the system is either a socioeconomic problem, a mental health problem, an addiction problem, problems at home. If we can start by addressing the underlying issues, we're going to eliminate a lot more of the people that are in the juvenile justice system. The way to do that is through counseling, diversion, and other measures that will allow us to treat the problem that's leading toward the crime, rather than just acting retroactively and addressing the crime once it happens. That's the bigger problem. Is why is this person? We have to answer the question, why are these kids ending up in the system in the first place? And if we address it from that perspective, then we'll be able to take great measures to reduce the number of kids that we're seeing in the juvenile justice system.
Paul, the same question to you.
Thank you. This is an area where I have a great deal of experience as a police detective overseeing our juvenile detective division. As a state legislator, 3 years ago, I was the statewide co-chair on a special commission on adolescent and juvenile crime. A number of the DAs were actually panel members. Senator Cindy Cream and I were the co-chairs. And we took a really deep dive into what can be done to try to stem this tide of juvenile crime, appropriate use of juvenile diversion. I think the other piece that is not talked about enough, and we've seen it not only here, but across the country, is the school to prison pipeline. We need to address this. So many young people are being caught up in a system where incarceration should not be the answer. I've done a lot of work on this. Some of the things that we can do, and I've looked at ways to disrupt this pipeline, increase mental health treatment in the schools, proactively put preventative programs in place. They talk about reducing class size, give more individualized attention to the students. And a big piece of this is something I'm a great proponent of, and I just had a meeting on this, is restorative justice. These are the things that we can do proactively. We need to make sure that we have these kids that are getting the attention they deserve. I've proposed to have a quarterly roundtable with school superintendents, school resource officers as well, to identify the kids that need the most help and proactively help them.
Thank you. You gave us a good segue to the next question. We were talking about a pipeline, but slightly different. And this is to you, Paul, first. What prosecutorial decisions would you make to disrupt the foster care to prison pipeline?
We've seen so many of these issues, and unfortunately, the cases that come to light have terrible consequences and come from a terrible place. And I think that doesn't even capture what's happening. This is all about prevention. I think it's being proactive. It's looking at these individual cases, whether it's the foster care system, whether it's the school to prison pipeline. I think a lot of the metrics that we use, not only to measure and get an idea of what's happening, but what's the proactive approach that we can do. A lot of it has to do with support, identifying what is the problem and what's the solution. We have a tremendous mental health issue in this country. We've got young kids that have all the challenges that they face in this world, challenges, frankly, that I didn't have to face as a young person and that my parents and grandparents didn't have to face. Society has evolved to such a point where we've got kids that have degrees of mental illness, degrees of depression. They turn to substance use, they turn to vaping. The DA has a strong, strong role to play here, not only in terms of action, but really to use the bully pulpit to make sure that we bring these things to light. Our foster care system has seen too many terrible, terrible things that have happened. I call it an all hands on deck approach. The DA is one part of a multifaceted, multidisciplinary system and answers that we need to implement.
Thank you. James, the question to you.
Thank you, Sue. I would break this down into a diagnostic issue. On the first part of that, I would look to see what the problem is within the specific foster care situation. In other words, there's obviously a problem with these kids. Is it stemming from something that is within them, whether it's a mental health or a substance abuse problem? Is that the diagnosis, and can we get treatment in that regard? Or is this somebody that's having a foster care, taking people in foster care for their own benefit and is not taking care of the child? Anybody, in terms of the prosecutorial side of this, and I think that's what the question asked, on whether or not we could do anything to prosecute people. Anyone in my administration that abuses the most vulnerable in society, be they the elderly, children, animals, again, we'll see the punishment side of the office. Anyone that's on the other side will receive rehabilitation. But in this case, it's more a question of diagnostic. Where is the problem starting in the pipeline? We can identify the people that should not be giving foster care, and we can potentially prosecute them for abusing children, for not taking care of them, for not living up to their responsibilities. And to the extent that they're actually committing crimes against these children, they need to be punished and they need to be taken out of the system. With respect to whether the child has underlying issues, we can address those through the rehabilitative side. We can address those through programs that address mental illness and or addiction or whatever other problem.
Thank you. Okay, James, this next question is to you first. Do you support bail reform? And if so, what is your vision? And if not, why not?
By bail reform, I think what is most commonly referred to with respect to bail reform is, am I going to take certain crimes outside of the realm of bail? I think in terms of the charge itself, my approach is simple. I'm not going to prosecute based on the nature of the charge. That whether that's these things that we're overusing for the 58As or the minor crimes, we have to, in order to achieve justice, we have to approach every single case and every single defendant based on the nature and circumstances of the offense and based on the nature and the facts and evidence presented to the court. And we'll make decisions. Most of the minor crimes now presented don't require us to just do a red flag and say, we're not going to prosecute shoplifting. When you do that, you send a bad message to the bad people. You can have situations where you have people take advantage of store owners as a result of knowing that they're not going to be prosecuted. And like I said, we've already seen the abuses of the 58As by using certain charges that can't be upheld that end up in dismissals and putting people in jail for lengthy periods of time while they're presumed innocent. So for me, I've argued thousands of bails over 24 years. The reform portion of it has already occurred in the sense that the court and the case law is now allowing people of indigent people, the ones that I represent, not to be held on bail based on their inability to pay, but on their ability to appear in court.
Okay, thank you. And Paul, the question to you about bail reform.
Sure. So the question is particularly to bail. So let's talk first about cash or cashless bail. Cash bail is intended to make sure that somebody returns to court, not in a punitive way. It's not meant to hold anybody that shouldn't be held. And in district court, judges make these decisions every single day. And if somebody has a history of defaults, chances are that they will have a higher cash bail put on them. If we take a look at the numbers of people who are incarcerated in Massachusetts, if we take a look at the Department of Correction, those who are actually doing time, serving a sentence, those numbers have gone down in the last 8 years. They've gone down 42%. On the other side of it, in the jails where somebody is awaiting trial, those numbers have either stayed the same or gone up. And I think that merits a review. We need to make sure that as long as we keep this cash bail system, that it's done in a fair way, simply to make sure someone returns to court. I'll tell you what I worry about. I worry about people who are on the lower socioeconomic spectrum, somebody who's repeatedly in front of the court and at some point ends up on a bail of $200, $300. It might as well be $1 million, and they end up being held. So what do we accomplish here? We hold somebody for months at a time while they're awaiting some type of disposition. Generally, by the next court appearance, when they go back in after some time, the case is resolved. And what happens? They present back on the streets again with the exact same issues that they went in with. That's one of the main reasons why, as the police chief, I created the community impact unit. That's why I had the mental health clinicians. So we kept those folks out of the system. The 58As is a separate issue. When we talk about bail, when we talk about the cash bail, there's other lesser restrictions that we could use. We have electronic monitoring. We have day reporting centers. We have drop into probation. We have curfews. There are so many other things that we can do. And I think it has to be a smart approach. I also think that the more we talk about this, the more we put a spotlight on it, I think we can come to a better resolution here. We want to make sure that people are not, I see my stop time, it came up without me warning.
I think we have a little.
So could I have a rebuttal?
Yes, sure.
Very
We can
briefly.
do 30 seconds to both of you. So James, you're first.
This is the difference between somebody that practices law and is defending these type of indigent defendants that's set on a $200 or $300 cash bail and someone that's never done it. They are not held, Paul. There is a bail fund in Massachusetts, thank God. And we're able to get them out under a certain amount of money, usually up to about $1,000. So I just want to educate the group that there are things that I've been able to do that many bar advocates are able to do. $200 or $300 is not going to keep anybody in jail. And if you were arguing bail, anyone that argues bail on a regular basis and is familiar with the bail fund would know that. Thank you.
Paul, 30 seconds to you.
Sure, I appreciate that. And I've seen so many cases where people were held on a low bail. I am familiar with the bail fund. I've seen that they bailed out people on multiple tens of thousands of dollars. And on the lower end, I've also seen people that were held. And I also see that the numbers of people that are held in the jails has gone up, while the people who are doing time, that figure has gone down. I've had enough of an education in my 32 years as a police officer and 8 at the State House making the law.
Okay. All right, Paul, this next question is going to go to you first. How will you ensure that your staff have the resources to adequately communicate with the people they engage with, including people with physical and cognitive needs, or those who need translation services?
I know how important that is. I actually just had a bill passed twice in the last 2 years that trained police officers to deal with special populations, particularly folks with autism and on the spectrum. This is a training issue. It's a selection and training issue, making sure that folks are competent and have the ability to make sure that they're communicating properly. It's also about making investments to make sure that we invest in the folks. It's investing in the staff, using the best practices. This is something in particular, you mentioned the interpretive services. I've heard a lot of complaints about the interpretive services. I can tell you as a longtime detective, it was frustrating when folks that had English as a second language were not getting the full benefit of these services that they should have. It's difficult enough for a defendant to be in court. It's difficult enough for somebody who speaks English as a first language to understand all of the nuances and the language and what's happening. It's extremely difficult if that person is not a native English speaker. I think we need to have a much, much bigger investment in the interpretive services. In fact, the ability and the availability of interpreters. This is a training issue, and this is something I've done this as a police chief. I know how to do it, and I would do it as a district attorney.
Thank you. James, question to you.
As I said, Sue, my law office, anytime you come in there, you can hear anyone speaking a variety of up to 5 different languages at any given time, whether it's Spanish, Arabic, Polish, English, Portuguese. We have very well-versed, and we have such a diverse clientele that we're required to provide for interpreters. I'm not sure if the question was addressing whether the trial court's falling short in providing for these services or whether the DA's office is currently falling short. I can tell you as a practicing attorney that we do a pretty good job in terms of the actual district court and superior court supplying of interpreters. Some of the languages that are not more common are more difficult, and we have limited number of say, Arabic and other Khmer type interpreters. But as to on a regular basis, and certainly we have difficulty with the hearing impaired too. That's a real problem in terms of the courts where we need to provide better services in that regard. But in terms of the DA's office, I'm going to have my partner who's fluent in Arabic coming with me and starting an immigration division within the office to be able to deal with all the issues regarding victim visas that have been neglected within the office. We'll have my assistant who will speak fluent Spanish. We'll have in-house people. We'll add in-house people that have the skills that are transferable. So they'll have a 2-for-1. We'll have somebody that's an employee working in the office that also has the ability to translate.
All right, James, next question is to you first. As district attorney, how would you organize and monitor complaints and investigations of police misconduct to comply with your constitutional requirements in court?
Thank you, Sue. I would investigate them with one of the problems that you have with any situation where you're investigating people that you would consider within your own in-house working environment is you have to have people that are objective in reviewing the cases. You can't have people within the same office reviewing the same people. So what I would do is I would create and what we have in the court right now, whenever this type of conflict of interest comes up, the court will recuse itself and send the case either out of county or to a different location. Police misconduct has to be investigated thoroughly, and the best way to do that objectively is to have an outside source come in to look at the issue with regard to the misconduct. You can't have these type of reviews being done completely in-house. So one of the things I would focus on right away is making sure that we have someone objective reviewing the case, every single case of misconduct. That would be the first policy, to make sure that what we're doing is we're looking at every case in an unbiased way, to make sure that we have fresh eyes, not somebody that knows this person is working with them arm in arm, not somebody that's with them on the job every day, not someone that reports to the same station, somebody that looks at this and can objectively say, this was wrong and it needs to be punished. This is the charge that has to be issued and you have to prosecute it. And in a lot of instances, it'll probably have to be prosecuted out of county.
Okay, thank you. Paul, the same question to you.
Sure. In my police career, I spent 17 years as the chief of detectives, and coterminous as the chief of detectives was the position of being in charge of what we call internal affairs. The internal affairs was the place where citizens could come in, make a complaint against the police officer. And for 17 years, I did that job fairly and making sure it was fair, not only to the complainant, but also to the police officer as well. The main reason why we do it properly, and we meaning in the internal affairs, was to keep the confidence of the public and make sure we keep the confidence of the police officers. When a member of the public comes in, it's probably not a place that they want to be, to come in and make a complaint against an officer. But as a department, if you are transparent and if you make mistakes and an officer makes mistakes, you have to address it. I've done that. I'll do the same as district attorney. I know when to investigate, I know how to investigate, and I also know when to recuse when it's better off going to another either district attorney or another agency. I've done that as well. I've had the very unfortunate duty to have to arrest some of my own police officers, to charge them in district court, in state court, in federal court. It's something that nobody wants to do, but you have to do it to make sure that you earn the public's trust. I've done it before and I'll do it as DA.
Okay, thank you. Paul, this next question is to you first. And this is actually, I think, going to be our last question of the night before closing statements. Do you support sentencing reform, including mandatory minimums? And if so, why? And if not, why not?
So I think sentencing is something that we can always take a look at. I know there was a sentencing reform commission a couple of years back. A bit of history here, because this is not a question where you can say, yes, I support, or no, I don't. Here's a little bit of history on the mandatory minimums. When I was a young detective and I had some really big drug cases where somebody should have gone to prison because they did some really consequential things, there was a disparity in the sentencing. And because of that, some people getting probation and some people getting long sentences, the legislature, some 33 years ago, put these mandatory minimums in place. I actually had a full discussion with Chief Justice Gantz, who has since passed, and I talked to him about why mandatory minimums came about. And he very honestly said to me, the disparity in the sentencing, judges were all over the map with it. Let's also be clear, the mandatory minimum sentences that we have now is a very, very small number of offenses, a very small of the most serious crimes, major drug trafficking. Let's keep in mind, we had 2,290 people died last year from fatal overdoses. Mandatory minimums for first-degree murder, mandatory minimums for some seriously terrible sexual assault crimes. I actually passed a bill to increase the penalty for trafficking in fentanyl. It's a very small number, and the mandatory minimums that are in place that have kept sentencing disparities out, I support.
Okay, thank you. James, the question to you.
Yes, I'm very much against mandatory minimum sentencing, and I'll tell you why. In regard to the cases that even still remain, let's talk about drug offenses, and let's talk about it in the practical sense, in the actual sense of a client that I represented. You have the same trafficking charge against somebody who was a client of mine named Molly, and she was abused, sex trafficked, and she was originally a Division I athlete. She got hooked on opiates, and she's been charged with carrying and possessing with intent to distribute a large amount of opiates that she was forced to carry as what's referred to as a mule for somebody else after being abused. There are 2 or 3 different cases pending against the bad actors, the evildoers that abuse her in this way, for the trafficking in federal court and superior court. This is a situation where she could face the same mandatory minimum sentence as someone that's actually peddling this poison for profit. That's wrong. We can't do that to her. We can't do that to people like her. These are the real life applications of how these laws affect people, and it can't continue that way. Taking discretion away from the judges, away from the system is against my overall approach. Again, I sound like a broken record, but you have to give every defendant an evaluation of their case based on the facts, circumstances, and evidence. And you can't paint everyone with the same brush like these Mando minimums do.
Yeah, Sue, 1 minute, please.
30 seconds. How's
30
that?
seconds.
Okay.
Let's be clear. The DA's office has discretion. They have the discretion not to charge a mandatory. They have a discretion to break that down. In the case that my opponent described, I cannot imagine a DA moving forward with that case under my administration where you would try to charge that person the same as somebody who's profiting as a drug trafficker. Mandatory minimums are in place. They reduce the inconsistencies, but they are also subject to good, appropriate, smart discretion.
Can I address that?
James, 30 seconds. Yes.
I can tell you it's happening right now under John Blodgett's office. That's not a hypothetical case. It's not a made-up case. That's a real case with a real person that's happening right now. I know that you support John's office, and you've indicated that you're going to steer the ship and continue on. I hope you'll be true to your word and not do what he's doing right now, because you just said that you wouldn't. I'm telling you, I'm here to tell you that they're facing that charge, and that's the way that this is happening right now. It's not a question of whether it's hypothetical. That's real.
Okay. We are going to move on to closing statements, and we're going to go in reverse order from where we started. I just want to say I see that there were questions in the chat, and we have a number of questions we didn't get to today, but thank you both for staying a little later. We're going just a little past 8 o'clock. All right, James, so 2 minutes to you for your closing statement.
Thank you, Sue. Thank you again for having us. I have a vision for this office that's based entirely on my 24 years of practice, the observations that I've made, not only in the Essex system as a bar advocate, but I've tried cases and represented thousands of defendants all over the Commonwealth. That's given me the ability to go to all of the district courts, or not all district courts, but many of the district courts in many of the counties, Plymouth, Suffolk, Middlesex, you name it. And I've seen what's working there, and I've seen what's not working here. And my 4-point plan from the very beginning of my administration as district attorney will address the following factors. I've already discussed the reduction of the 58A motions to address the social justice problem, where we have a disproportionate number of people of color being incarcerated. That will be my first step, day one. I've also addressed that I have a super lawyer for a partner who's an immigration expert. We will come in and address the fact that there are U visas that are not being timely processed by this administration, and we'll correct that error to help these victims get the status that they so richly deserve. Thirdly, I will give more discretion to the ADAs and the district courts. It's hard enough for them to work with less money, for a lower pay than they would get in the private sector. They deserve much better treatment than that. They deserve some freedom to be able to evaluate their cases. And more importantly, when you give them discretion as somebody that's supervising them, you'll have the ability to determine whether or not they're making sound decisions. By letting them make decisions, you can determine whether they should be promoted, whether they should be spoken to, whether they should be in a situation where they're making the right call for you as your representative in the court. Finally, based on my review in other counties, I will address the issue of IT. We are using woefully outdated technology in the Essex system. That needs to be updated. My name is James O'Shea. I've been an attorney for 24 years. I humbly ask for your vote on September the 6th, and I appreciate you giving me the time to speak with you this evening.
Thank you very much. And Paul, 2 minutes to you.
Great, thank you, Sue, and thank you to all the presenters. This has been an extraordinary forum, and let me just say I salute all the work that you've done. I've had the opportunity to work with almost all of the forum presenters here, and I have great respect for the work you're doing. A couple of things I want to make sure we're clear about. John Blodgett's name is not going to be on the ballot. Paul Tucker's name is going to be on. And if you take a look at my record, what I've done, I've been a voice for the marginalized. I've stood up when sometimes it was difficult. I've led a very public life. I've had 40 years of public service. You can look up every vote I've taken in my 8 years in the legislature, some tough votes, but I've always stood up. I've never been afraid about losing votes. When I stood up for the LGBTQ+, the transgender protection, people told me I might lose votes. I'd rather lose an election than not stand up for people who need a voice. I've been that voice for them. I was a police officer for 32 years. I've been an attorney for over 20 years. I teach at the university and the community college level. I teach criminal law. I teach criminal investigation. I've been out front in my community. I've coached youth sports. I've been on the board at the Salem Y, the Boys and Girls Club, Salem Voice, Salem Award. I've done all of that. If you take a look at my breadth of work, the body of what I've done, I believe it lines up precisely with what a district attorney does. It's leading the office. It's doing it with vision. It's doing it with integrity. I've done my best work as a public servant. I'd like to continue. That's why I asked for your vote on September 6th. This is not something that I take lightly. I've had a great career in public service. I've always looked to serve. This is what I want to continue doing. I've been in every county. I've been all across Essex County. I've been across the Commonwealth in my career. I also ask you to take a look at the people who are supporting me. From Maura Healy, who's endorsed me, John Blodgett, every mayor with the exception of 2 that are staying out of it, local officials, unions, because of the work I've done. I appreciate it, and I ask for your vote. Thanks very much.
Thank you very much. James O'Shea and Paul Tucker, thank you very much. I wish you luck. And now I'll turn this over to Jean, who will wrap it up.
Wow, powerful conversation and really good information. My name is Jean Morrison. I am the platform chair for Massachusetts Women of Color Political and Civic Leadership. I'd like to close this webinar by thanking the candidates, Paul Tucker and James O'Shea, for taking the time to participate and share the responses to the questions posed to them. I'm sure the voters appreciated hearing your thoughts tonight, so thank you. I'd also like to thank our moderator, Sue Flykop, for her professional and well-executed facilitation, and Jeb Mays for the Spanish translation this evening. Additionally, I'd like to thank all of the organizations and community partners who sponsored this forum. Your collaboration, hard work, and dedication to voters is greatly appreciated. Most of all, I'd like to thank you, the voters, for your participation tonight. Now, please come out and vote in the fall. We'll post the following information for you into the chat. The primary election is September 6th, general election November 8th. I want to note that there are no Republican or other party candidates running, so the primary election is very important and will determine which of these 2 candidates shows on the November ballot. If you haven't registered or need to check your voting status or verify where to vote, please visit online voter services at vote411.org or visit the Secretary of the Commonwealth of Massachusetts, and that web address will be posted in the chat. The deadline to register to vote in the primary is August 27th. This forum was concluding a portion of a 3-part series, so do take a moment to also review the District Attorney and Sheriff Educational Forum, the first in our series that provides a deep dive into the data and specifics to the Essex County, as well as the roles and responsibilities of the DA, the District Attorney, and the Sheriff. Additionally, last Thursday, we provided a similar candidate forum for the Essex County Sheriff, another role up for election this term. Thank you again. That concludes tonight's program. Have a good evening.
Thank you.